vested with the election authority under section 39 capital A. They cannot defeat the very purpose of his constitution, saying that majority member sent a resolution, I accept, okay. Tomorrow another resolution comes before them, it is also by majority member, it is also okay. Day after tomorrow like that. There is an end for all these things. Then why the election authority must be there? Assistant registrar, joint registrar, assistant, they are enough for doing all these nonsense things.
Yes.
Therefore, my lord, primary questions which we would like to address in the matter is, there is a failure in discharge of duties, in accepting the discharge of duties, in accepting the process forwarded by these two societies are concerned. What could have been examined by election authority is the reason indicated that there is an inadvertence. Whether it first basically could it constitute a substantial reason at the long distance of more than 1 month, 5 days.
And it should have rejected it.
He should have been recorded a reason. He could have been accepted. I won't agree. I'm not saying that he don't have the power. He could have been say, yes, I satisfied. This reason appears to be substantial reason. I allow X to become the delegate in place of Y. We have no watch to rise before your lordship. We can ask your lordship to test the correctness of that finding. Now there is no finding at all.
Yes.
Therefore, my lord, in the beginning I said, we are not depends upon factual aspects. Purely a legal question we would like to address. Based on that we founded 21(3) and 39 capital AA requires an interpretation in the light of the language employed in the Act as well as under the language employed in the impugned resolutions are concerned. This cannot be, or it would not be, examined without there being the placing the original records before your lordship. What prompted? What are the things there?
Right. Next.
My lord, then my lord, your lordship, then go to Rule 13 capital BB, my lord. Appointment of an election office by the state government. Then 13C, the government may advise the election authority in suitability of the dates of conducting elections as per subsection 2 of section 39 capital A of the Act for administrative reasons to be recorded in writing. Again in subsection 2, subrule 2, subject to the general superintendent's direction of the cooperative election authority, the chief executive of the society shall prepare electoral roll for the elections of a cooperative society. The list so prepared by the chief executive shall be verified and approved by the election officer. Shall be verified, then approved. It is not mere approval. Verification and approval is the twin side of this incident.
Yes.
Of members representative and etc. then, and submit the set list to the election officer along with the elected books, records and documents and any other information as the election officer may require at least 50 days, 60 days before the date of election. The cooperative election authority shall call upon the executive of the cooperative society to obtain from the member society name of the authorized member of the board of such society as a delegate, together with a resolution of the board of the said society, specification signature, specimen signature, along with the photographs of the delegate, duly attested and bearing the seal of the society and furnish all such information under subrule 5.
Yes.
In the context of this background, my submission would be, my lord, our stand is very clear. We are not questioning authority of an exchange of a delegates are concerned. Our complaint is with reference to the manner in which a exchange have taken place it is not happily done, or it is not satisfying the requirement under the law.
Not the decision, but the decision-making process.
Yes,
Yes.
decision-taking process.
Hmm.
And an authority on whom a highest responsibility is imposed, it acted in a mechanical manner and a casual sense.
Hmm.
Therefore, my submission is, my lord, an NCL to us. Yes, a complaint is received. When all these efforts rendered futile, we instituted a PCR also on the similar complaint.
Hmm.
In the background of that, my lord, other side may not took us very irresponsibly. They made a statement, it's a finding of fact. It for that reputation is not maintainable. I cannot understand. This is one of the reasons this is supporting us. If my lord, election authority exercises the function in the light of section 39 capital A, we could have been able to establish before the election authority. This has happened there.
Yes.
We are deprived of an agency to scrutinize our complaints. In the light of the process which is before them, they are bound to take a decision on it.
Yes.
I think something more would be supplemented, my student, my lord, I can say.
Captain, student. You also look at
Captain this time is on the other side, my lords.
Now we have a change in the combination.
You are appearing for the petitioner.
Please, my lords.
You can't have two counsels appearing. Only one counsel.
And you know, they are assisting the legal issue. Is,
Micus.
yes.
Obligation ಜಾಸ್ತಿ ಆಗೋಗುತ್ತೆ ಮೈಕಸ್ ಅಂತ ಹೇಳಿದ್ರೆ.
Lords, nothing on the back.
ರಾಜಗೋಪಾಲ್.
Lords, if your lords were to see the definition of delegate, Lords,
Prior to 2021 or after?
Lords, now as things stand, the reason why we have to look in the definition of the delegate prior to 2021 is for the reason that there is a metamorphical change, my lords, in the manner in which the delegate is defined. Lords, delegate, Lords, earlier to 21 was appointed to represent the cooperative society in other cooperative society. Lords, that's all what it meant. After that, it was changed to say delegate means a director of a cooperative society appointed by the board to represent the cooperative society in any other cooperative society with power to participate and vote in the general meeting and to contest or propose or second in the election of the cooperative society to which he is appointed as a delegate. Another society which will be either a secondary society or the federal society as the case may be. In substance remains the same except by saying that the specific powers, that power to participate, power to vote in the general meeting, contest, propose, etc., etc. My lord, this is specifically added, but in substance, my lords, there is absolutely no change. It was a larger perspective with which it was there, but now it is in the same perspective, but the definition of powers are there, which is rather inclusive in nature. But the reason why I read this to your lordships is, if your lordships were to now have a look at section 21, my lords, of the Act.
Yes.
The board of a cooperative society, which is a member of another cooperative society, may appoint one of the members of the board to vote on its behalf in the affairs of that other society. Notice, I just pause here. I'll not go to subsection 3 for a minute. Notice, now, once this resolution is required to be passed, what are the stages contemplated under the scheme of the statute when such resolution is mandated? Notice, now, the point which I am raising for your lordship's consideration is, once the delegation is sent and it is incorporated as a part of the draft voters list, which is the power or the provision for, because this then becomes an electoral process. Preparation of electoral roll is a part of the election process. Which is the provision which enables them to change the delegate after the incorporation of the delegate in the electoral roll? Now, if your lordships were to see Rule 13D, my lords, there appears to be a finality once that is given. That is what I could understand, my lords. 13D, society, the name of an authorized member of the board of such society as a delegate, together with the resolution of the board of the said society, and the specimen signature along with the photograph of the delegate duly attested and bearing the seal of the society and furnishing all information under sub-rule 5. So subsection sub-rule 6 comes first, and then your lordships may kindly come to sub-rule 5. Chief executive of every cooperative society shall prepare the draft list of eligible voters or representatives and delegates with right to vote. This is a process. Now, how can this be meddled with? Then the final electoral list, my lords, in sub-rule 7. Notes, the reason why I am submitting this is, notes, just peculiar to the present case, the direction was issued, my lords, in terms of sub-rule 6, pursuant to which the chief executive had requested all the member societies.
Section 5 is which of the societies are eligible to vote
Lords,
in a
just two, my
federal
lords.
society.
Yes, now draft list of eligible members are representatives and delegates with right to vote. Lords, the preparation of the
If it is available,
Lords, if it should be
eligible
available.
members-
Lords, that's the reason why I said, my lords.
first issue is eligible members
Yes.
or representatives and delegate with right to
Lords,
vote.
eligible members is
With right to vote.
eligible members is with reference to the individual members. In the earlier Lords provisions, there has been a reference saying that wherever the member appears, you will have to use the word the delegates. Lords, they are used interchangeably in the earlier portions. I'll read this to your lordships in section 21 itself. I think this kind of provision is there. Lords, members is relatable to them or representatives and delegates with right to vote. Lords, the reason why I am making this distinction is there are members who will submit the list of delegates. (5)(4), the draft voters list of the delegates is published.
Yes.
Lords, now this is pursuant to the resolution dated 22/3/2025. Now this is the resolution under which the delegates have been made, that is acted upon. List is submitted, list is accepted by the chief executive officer. Then the list is prepared and sent to the cooperative election authority, which is the requirement, consisting of the delegates of the member cooperative societies. Now, once this process is completed, under the scheme of the rules, nothing permits a change in the list of representatives.
That the substantive act provides for it.
Lords, now your lords may kindly see the act, lords, whether it can be interpreted to an extent that after the commencement of the election process, because in a cooperative election, lords, the election process is deemed to have commenced from the date on which the preparation of the electoral roll starts. That is Sant Janardhan's case. Now your lords may kindly see, lords, section 22/21 meeting of any other cooperative society shall not be changed, except number 1, by a resolution passed with substantial reasons. Number 2, in a board meeting with 2/3 majority of the members present and voting in such meeting. However, a cooperative society shall not nominate or appoint any member of the board to vote on behalf of it for more than 2 cooperative societies. Then explanation, my lords, for the purpose of section 20, this section and wherever it occurs, the word delegate means a member of a cooperative society to represent the society in the other cooperative societies. The reason why I wanted to draw the parallels is that wherever member is used, the member once nominated cannot be changed except under 2 specific conditions. Now, when this power can be exercised is the question. Lord, this has to be read in consonance with the rules. Lord's, rules provides, the reason why I am submitting this to your lordships is, lordships may kindly take 13D6 for a minute, lords. Again, there is a reason why I am saying this. It is not that some kind of laissez-faire that they will pass 10 resolutions, 15 resolutions, 10 people this side, I'll pay money today, he will vote. One more fellow, he will vote, pay money, he will also get one more resolution. That cannot happen in this process. 13D6, my lords, cooperative election authority shall call upon the chief executive cooperative to obtain the member society, the name of the authorized so and so. What is submitted pursuant to this alone gets into the list. Lords, it is not that they do it at their whims and caprice. When it comes to the preparation of an electoral roll, there is a prelude to it. Otherwise, if this is the in nature of interpretation, sabotage is the easiest way. Any person who is a delegate on the last day, they will sit, 8 of them will sit and say, no, we have cancelled the delegation. We don't want to even go and vote. Or they will vote, delegate somebody else who will not go and vote, so that the society itself will not have a right to vote. This is definitely not the object. But when it comes to the election, I can understand about the other meetings, who has got a right to vote in a meeting. Absolutely no difficulty. But when it's a question of preparation of an electoral roll, right to vote in a meeting is a different context. Right to vote in an election is also a different context, in the manner in which it is presently described, because right to vote in a meeting comes out of the purview of the election authority and the process to be followed through the election authority. It is completely distinct. There is a special procedure provided for insofar as the election, the preparation of electoral roll and the election process is concerned. It cannot be equated with a general right to vote in any meeting, a typographical mistake or otherwise. They say we have now changed the delegate. Where is that power, milords, after this process is commenced?
Yes.
Now, can I request, milords, having made this point, now I wanted to draw the distinction why there is no substantive right. Lords may kindly have a look at subsection 3 of section 21.
Yes.
A member once nominated by the board of a cooperative society under clause A of subsection 2 to vote on its behalf in any meeting. Now, your lords may kindly see what is the definition of delegate. Why this distinction has come about? Probably, milords, this is what appealed to me. Delegate means a director of a cooperative society appointed by the board to represent the cooperative society in any other cooperative society with power to participate and vote in general meeting, to contest or propose or second in the election of the cooperative society to which he is appointed as a delegate. The powers are kept distinct. Right to participate in any meeting and the electoral process is kept distinct. Probably, I may not be overstretching myself, but probably this is designed because when it comes to the preparation of an electoral roll, there is a completely distinct procedure which has been followed, milords, by the societies, where the state election authority, the cooperative election authority directs the chief executive of the federal society or the secondary society, as the case may be, to get the delegate. That, milords, if that was to be the reason, milords, 13D6 would have incorporated what was substantially a part of, milords, 39 or 21(3).
Yes.
Milords, therefore, milords, my respectful submission in this regard is that procedurally and substantively, it has been intended that after the draft election, milords, only to say that milords, subsection 3, milords, the language is very interesting, because this is like imposing extra caution, and this kind of language, milords, has been interpreted by the court saying that these are the kind of languages which is inserted only to ensure the mandate of its adherence. Milords, now your lords may kindly see, milords. A member once nominated by the board of a cooperative society under clause A of subsection 2 to vote on its behalf in any meeting of any other cooperative society shall not be changed. That is the mandate. You should not change. Then there is an exception given when you can change it, except by a resolution passed with substantial reason in a board meeting. So I will not get into the question of majority. Substantial reason which is to be recorded in the board meeting. Now what they have done here is, I will leave it at that, because every fact scenario also stands on the test of its acceptance on the principles of administrative reasonableness. Whether a reasonable man should really accept this story, this will always loom large in every case, milords, as to whether this probability or the improbability will definitely arise in the case. Milords, what they say is that the resolution which was passed on 22/3/2025, whereby this Mohan Reddy was appointed as the delegate, was at the time of its communication or writing, or at the time of its communication, is a mistake which is committed by the chief executive officer. It's an error committed by him, and therefore, by committing such of the errors which is permitted, 3 of them, their signatures is forged, which is very serious in nature. 2 of them are not notified. But still 8 of the numbers are there. The numbers is there with us. They say that no, now that it's a mistake which we have. It's para 7. He says that he was not willing and that.
Number 6, sir.
Yes, Lords. Respondent number 6.
Para?
By one of the beneficiaries, what I can say, Lords. Because Raja Reddy is replacing Mohan Reddy. Mohan Reddy gets himself nominated in another society.
Paragraph?
Para 7, Lords. The further amendments that the meeting held on 22/3/25 unanimously nominated this respondent to be the delegate of the society.
Just one.
My apologies. My apologies.
Reddy was filed for 9 to 14.
So sixth respondent
Lords, there is a-
independently filed that
Yeah,
respondent.
Independent agreement.
Yes, independent.
Lords, it appears to have been filed on 26/25.
26, 25, 14. R6, there is a separate objection. Yes.
Para 7, Lords. Resolution copy and change ಆಗಿರೋದು. The further amendments, Lords, the second sentence, Lords, the further amendments therein that in the meeting held on 22/3/25 unanimously nominated this respondent to be the delegate of the society to cast vote are also not in dispute. It is pause here. He says it's not in dispute. Now your lordships may kindly see the resolution filed on 14th of July, which is called as application under section 151 for additional statement of facts. In that I have produced a resolution because what is glaring, my lords, what is patent need not be inquired into. It's not yet latent also.
Yes.
Now your lordships may kindly see the resolution. Page number, my lords, this is
Additional statement of fact. All the documents are there in it.
the resolution in particular, my lords. I think this, by reading this,
Where is the resolution page number?
lords, page 27, my lords, along with this application for additional facts.
ಅಂತವಲ್ಲ, yeah.
Application for additional facts.
Additional facts ಅಂತ ಎಲ್ಲಾ ಡಾಕ್ಯುಮೆಂಟ್ ಕಂಪ್ಯಾರಿಯಂ ರಿಪಿಟಿಷನ್
Just-
ಒಳಗೆ ಸರಿಯಾಗಿಲ್ಲ ಅದು.
It's a compilation of,
ಅಲ್ಲೊಂದು ಎಲ್ಲೆಲ್ಲೋ ಇದೆ. ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಅದೆಲ್ಲ ಒಂದೇ ದಿನ ಫೈಲ್ ಮಾಡ್ತಾರೆ.
A1 of 25.
yes, my lords. So, a little bit compilation, my lords. It's
Yes.
in that page number 27, which is annexure 7,
Roman
7, page 27.
Yes.
May I read it, my lords? Number 3, ಕೋಲಾರ ಮತ್ತು ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಡಿಸಿಸಿ ಕೋಲಾರ ಇದರ ಆಡಳಿತ ಮಂಡಳಿಗೆ ಮುಂದಿನ 5 ವರ್ಷಗಳ ಅವಧಿಗೆ ನಡೆಸಲು ಉದ್ದೇಶಿಸಿರುವ ಚುನಾವಣೆ ಸಂಘದಿಂದ ಡೆಲಿಗೇಟ್ ಅನ್ನು ಬದಲಾಯಿಸಿ ಆಯ್ಕೆ ಮಾಡುವ ಬಗ್ಗೆ. ಕೋಲಾರ ಮತ್ತು ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಡಿಸಿಸಿ ಕೋಲಾರ ಇವರ ಆಡಳಿತ ಮಂಡಳಿಗೆ ಮುಂದಿನ 5 ವರ್ಷ ಅವಧಿಗೆ ನಡೆಸಲು ಉದ್ದೇಶಿಸಿರುವ ಚುನಾವಣೆಗೆ ಸಂಘದ ವತಿಯಿಂದ ಡೆಲಿಗೇಟ್ ಪ್ರತಿನಿಧಿಯನ್ನು ಬದಲಾಯಿಸಿ ನೇಮಕ ಮಾಡಿ ಕಳಿಸುವ ಬಗ್ಗೆ ಚರ್ಚಿಸಲಾಯಿತು. ಸಂಘದಿಂದ ಆಯ್ಕೆಯಾದ ಸಂಘದ ಅಧ್ಯಕ್ಷರಾದ ಮೋಹನ್ ರೆಡ್ಡಿ ಬಿನ್ ಶಿವರಾಮ್ ರೆಡ್ಡಿ ಹಿರೇನಾಗವಳ್ಳಿ ಗ್ರಾಮ ಇವರ ಡೆಲಿಗೇಟ್ ಕಾರ್ಯದರ್ಶಿ ಕೈ ತಪ್ಪಿನಿಂದ ಆಗಿರುತ್ತದೆ. ಹಿರೇನಾಗವಳ್ಳಿ ಗ್ರಾಮ ಇವರ ಡೆಲಿಗೇಟ್ ಕಾರ್ಯದರ್ಶಿ ಕೈತಪ್ಪಿನಿಂದ ಆಗಿರುತ್ತದೆ. ಸಂಘದ ಕಾರ್ಯದರ್ಶಿ ಕೈತಪ್ಪಿನಿಂದ ಆಗಿರುವ ಡೆಲಿಗೇಟ್ ಪ್ರತಿನಿಧಿ ಬದಲಿಗೆ ಸಂಘದ ನಿರ್ದೇಶಕರಾದ ರಾಜಾರೆಡ್ಡಿ ಬಿನ್ ನಾರಾಯಣ.
Yes.
ಅದರಲ್ಲಿ ಸೇಮ್ ಕೋಲಾರ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಡಿಸಿಸಿ ಬ್ಯಾಂಕ್ ಕೋಲಾರ ಇವರ ಆಡಳಿತ ಮಂಡಳಿಗೆ ಮುಂದಿನ 5 ವರ್ಷ ಅವಧಿಗೆ ನಡೆಸಲು ಉದ್ದೇಶಿಸಿರುವ ಚುನಾವಣೆ ಸಂಘದ ವತಿಯಿಂದ ಡೆಲಿಗೇಟ್ ಪ್ರತಿನಿಧಿಯನ್ನು ನೇಮಕ ಮಾಡಿ ಕಳಿಸುವ ಬಗ್ಗೆ ಚರ್ಚಿಸಲಾಯಿತು. ಸಂಘದ ಅಧ್ಯಕ್ಷರು ಉಪಾಧ್ಯಕ್ಷರು ನಿರ್ದೇಶಕರಾದ ದಿನಾಂಕ 22/3/25 ಶನಿವಾರ ಬೆಳಗ್ಗೆ 9 ಗಂಟೆಗೆ ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸಿ ಕಾರ್ಯದರ್ಶಿಯವರು ಕೈತಪ್ಪಿನಿಂದ ಡೆಲಿಗೇಟ್ ಪ್ರತಿನಿಧಿಯನ್ನು ಅಶ್ವತ್ಥಪ್ಪ ಕೋಮ್ ದೊಡ್ಡ ಮರಳಪ್ಪ ಇವರನ್ನು ಡೆಲಿಗೇಟ್ ಪ್ರತಿನಿಧಿಯಾಗಿ ಆಯ್ಕೆ ಮಾಡಿ ಕಳಿಸಿರುತ್ತಾರೆ. ಆದ ಕಾರಣ 24ರಂದು ಭಾನುವಾರ ಸಂಜೆ ಗಂಟೆಗೆ ಸಂಘದ 20ನೇ ತಾರೀಕು ಮಿಲಾಟ್ಸ್ ದಿಸ್ ಇಸ್ 28 ಮೇಲ್ಗಡೆ 28 ಅಂತ ಡೇಟ್ ಇದೆ, ಇಲ್ಲಿ ಕೆಳಗಡೆ 20 ಅಂತಿದೆ ಪಾಪ. ಅದು ಒಳ್ಳೆ ಡೇಟ್ ಇದೆ, ಇಲ್ಲಿ ಕೆಳಗಡೆ 20 ಅಂತಿದೆ ಪಾಪ. ಅದು ಒಳಗೆ ಒರಿಜಿನಲ್ ರೆಸಲ್ಯೂಷನ್ ಇಸ್ ಆನ್ ದ ಪ್ರೀವಿಯಸ್ ಪೇಜ್. ಅದು 28 ಸ್ವಲ್ಪ ತಾವು ನೋಡಿದ್ರೆ 47 ಅಲ್ಲಿ 20ನ್ನ 28 ಅಂತ ಕೈ ತಿದ್ದಿದ್ದಾರೆ, ಅಲ್ಲಿ ಬಾಡಿನಲ್ಲಿ ತಿದ್ದನ್ ಮರ್ತು ಬಿಟ್ಟಿದ್ದಾರೆ. What is all these things? The reason why I said this, my lords, is that change of delegate is not permitted at all. The reason why the substantial reasons is incorporated is that it should not be a number game. They can't say that this is going to be a number game and therefore we can do anything at any point. Face of it, and a patent admission that something of the nature like this, you know, as that 21(3) would permit the change of delegation after the sending of the delegation pursuant to sub-rule 6 of Rule 13D. The substantive reason plays a very crucial role, and in this case, I am in a position to demonstrate that substantial reason which they want to cite. Now they are together, my lords, of course. I cannot dispute.
So long as they are together, it is not a problem.
They are together.
If you join, you may shift this side or they may shift
That
this
of course,
side.
lords, it's happening. Musical chair is always happening.
We are not fighting.
We'll deal with it as on date, that's all.
Lords, in a given case, my lords, it's not easy for us also, my lords. In a given case, we have to understand and then present. So that's, lords, I'm so grateful for your lordships accommodating me, my lords, to address myself.
1 minute, my lord.
Yes, please.
With your lordship, please. Wasting your lordship's 10 minutes. A particular paragraph I wanted to find
ನಿಮ್ದೇ
out.
ಬೇರೆ ಮ್ಯಾಟರ್ ರೀಚ್ ಆಗಲ್ಲ ಅಷ್ಟೇ ಹೇಳಿ.
Or I can submit.
ಹೇಳ್ಬಿಡಿ, ಮುಗಿಸಿ, ಅವ್ರದ್ದು ಮುಗಿಸ್ತೀವಿ.
Para 113 of the judgment. That Mohinder Singh's case. Para 113.
Can I seek your lordship's excuse?
Great. ನೋಡಿ ಅವ್ರು ಹುಷಾರ್, ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಓದಿ. ಎಸ್.
Article 324(1) vest in the Election Commission the superintendent direction and control of the preparation of electoral rolls for the conduct of all elections to the parliament and the legislature of every state and election to the offices of the president and vice president held under the constitution. Article 324(1) thus quoted in wide terms, power in democratic setup as in the pattern of a polity is to be exercised in accordance with law. That is why Article 327 and 328 provide for making a provisions with respect to all matters relating to a connection with an election for the union legislature or the state legislature respectively. Appropriate laws are made under Article 327 by the Parliament as well as 321 by the state legislature. The Commission has to act in conformity with those laws and other legal provisions made thereunder. Even so, both Article 327 and its own right as a creature of Constitution in the infinity variety of situation that may emerge from time to time to such Lord democratic hours, every contingency could not be foreseen or anticipated with precision. That is why there is no heading of Article 324. Commission may be required to cope up with some situations which may not be provided for the enacted laws and the rules. There seems to be reason decree for the opening clause of 324 operative and effective when it is reasonably called for a vacant area. There is, however, no doubt whatsoever, Election Commission will have to conform the existing laws and rules in exercising fair elections in powers and performing manifold duties for the conduct of free and fair elections. The Elections Commission is the highest powered independent body which is irremovable from the office except etc., so and so. There are same situation where section 21 subsection 3 added to the statute. All four scenes can be expected at a time. Their changes would warranting changes must be satisfied with the requirement of qualifications that a 2/3 majority among the members are present and voting with substantial cause.
Yes.
One cannot be detached by the another.
Yes.
This is my submission.
Yes, Mr. Patel.
Please.
Plain and simple, two submissions, my lord, with regard to other before coming to other aspect. Respondent number 6 and 7 both are parties to the resolution,
Both resolutions.
both resolution.
Yes.
There is no dispute between them as regards change of delegate that has been done. Of course, fourth petitioner was absent, have signed the resolution. Now they are denying it. It becomes a matter with regard to this thing. Now, your lordship may kindly see a submission was made. Once they call for a delegation and delegation is given, it is published, it is over and there cannot be a change, etc. That under the rules, it is not so. Your lordship may kindly see 13D. 13D3. The election officer shall take steps for publication of voter list in the following manner, namely, for publication of draft eligible electoral list, a list of defaulters, a list of members whose payment falls due before the election date, clear 50 days. It would be a draft list. Calling for objections, if any, calling upon the defaulter members to repay the amounts due to the cooperative societies on or before 30 clear days prior to the date of election. The scrutiny and verification of the voter list after payment of by defaulters clear 20 days before the date of election. Now kindly see D. For publication of final eligible voter list before 15 days prior to the date of election. That is, the date 15 days would be the date a day prior to final list. Therefore, the submission that it became final list. And your lordship did pose that question, though they avoided answering it. Here, the list of members is not any particular person. List of eligible members is a society. Therefore, respondent number 5 society is a eligible voter. It is in the voter list. There is no change about that member. Now, who represents respondent number 5 is the only thing that is to be seen.
Yes.
A submission was made. Once process under rule 13 and 14 starts, there cannot be a change, etc. is not correct because it remains a draft list. And apart from that,
Your submission is until the final list is published, any change can happen.
there can be a change can
But
happen.
you also agree
Then
that
let us,
after final list is published, no change.
after the nomination filing starts, there can be changes only by orders of defaulter or disqualified. An order is passed by a competent authority. Though that can be the situation after that publication of final list.
Yes.
Also, your lordship may kindly visualize a situation. So and so, X was delegate. He died. Society remains a eligible voter.
Can it be
And
deprived?
society, there can be a situation to substitute someone.
Yes.
That probably will not happen without intervention of the court.
Yes.
In a given case, we may point out that on such and such a date it has happened, therefore for voting so and so may be permitted, delegates have passed the resolution, etc. Now, apart from all these things, whether under 21 anything of change is contemplated, I would respectfully submit 21 provides for change. There can be 3 situations Kindly see section 21, Mala. Subsection 2,
Yes.
2A provides for electing or selecting a delegate. Kindly see the provision. After selection, provided that where a new board has been elected to a cooperative society, such newly elected board shall send a delegate or nominee to any other cooperative society where it is a member. 21A resolution has been passed.
As a division bench judgment.
In the meanwhile, primary society
Bench judgment.
in the meanwhile, primary society election is held. So newly elected board, if it can within that time pass the resolution, it can pass the resolution. It don't require substantial reason or anything. Once election is held, newly elected board is permitted to do it, provided they have that time lag, at least communicating it to the authorities to get in. Difficulty at all to say that there cannot be a change, etc., is not correct. Now, 21.3 may kindly be seen.
Yes.
21.3 is a situation where the present respondent number 6 is given a right. A delegate who has been elected is given a right. A member once nominated by the board of a cooperative society under clause A of subsection 2 to vote on its behalf in any meeting of any other cooperative society shall not be changed except by a resolution passed with substantial reasons in a board meeting by 2/3 majority of the members present and voting in such meeting. Respondent number 6, a delegate, an existing delegate, if he is to be changed, it should be by a substantial reason and it requires 2/3 members to vote. It is a right given to the sitting member. If sitting member himself is not this thing, there is no question of somebody else taking objection. This thing, there is no question of somebody else taking objection. It is only that sitting member who can say, I cannot be changed.
It does not say that.
It is
One
so.
nominate shall not be changed. Aste.
Shall not be changed for a
could-
substantial reason.
Not be changed. Aste.
Shall not be changed for a
could-
substantial reason is for that man. It is that man who is aggrieved.
Looked at another angle.
I will come.
Also the board,
I will also
unless
come.
by
to-
2/3 majority.
Yes, ma'am.
Even the board has a right.
Therefore, it said 2/3 majority. He is
First-
elected by majority,
First time is a simple majority.
by simple majority.
Second time
But
is-
if he is to be changed, it should be by 2/3 majority.
Yes.
The safeguard is with regard given to the existing member. 2. In the instant case, let us assume everything in their favor. I will only put it like this, Miller. Respondent number 6 says, I don't want to go, you go. And there is
Appoint
time.
somebody else.
Yes, appoint somebody else. I don't want to go, appoint somebody else. Let us say, leaving apart this case, the respondent number 6 says, I have been nominated as a delegate. I don't want that. It becomes a vacancy. Actually, by simple majority, they could have done it. In view of the vacancy, we are electing so and so.
Vacancy is not contemplated for this.
Allah, if respondent number 6 says, I don't want to be a delegate, I surrender, I resign. And it is before 15 days. Then it becomes a vacancy. Even by simple majority, they could have done it. But in this case, they have said that so and so, who was the president was nominated as delegate.
Yes.
That was by a mistake,
Hmm.
and that president presides over that meeting.
Hmm.
He says he acquiesces to it. That was by a mistake, and we change it with so and so. Respondent number 7. Kindly see that meeting notice. It is not something it is hidden or done something this thing. Along with the writ petition, it is produced. ವ್ಯವಸಾಯ ಸೇವಾ ಸಹಕಾರ ಸಂಘ ನಿಯಮಿತ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ಇದರ ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿ ಸಭೆಯನ್ನು 28/4/25 ಸೋಮವಾರ ಬೆಳಿಗ್ಗೆ 10 ಗಂಟೆಗೆ ಸರಿಯಾಗಿ ಸಂಘದ ಅಧ್ಯಕ್ಷರಾದ ಎಚ್.ಎಸ್. ಮೋಹನ್ ರೆಡ್ಡಿ, ದಟ್ ಇಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 6 ಡೆಲಿಗೇಟ್, ಇವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ತುರ್ತು ಸಭೆಯನ್ನು ಕರೆಯಲಾಗಿದೆ. ಆದ್ದರಿಂದ ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿ ಸದಸ್ಯರು ಸಭೆಗೆ ತಪ್ಪದೇ ಹಾಜರಾಗಬೇಕಾಗಿ ಸೂಚಿಸಿದೆ. ಕೈಂಡ್ಲಿ ಗೋ ಟು ಸಬ್ಜೆಕ್ಟ್ ನಂಬರ್ 3. ಕೋಲಾರ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಡಿಸಿಸಿ ಬ್ಯಾಂಕ್ ನಿಯಮಿತ ಕೋಲಾರ್ ಇದರ ಆಡಳಿತ ಮಂಡಳಿಗೆ ಮುಂದಿನ 5 ವರ್ಷಗಳ ಅವಧಿಗೆ ನಡೆಸಲು ಉದ್ದೇಶಿಸಿರುವ ಚುನಾವಣೆಗೆ ನಮ್ಮ ಸಂಘದಿಂದ ಡೆಲಿಗೇಟ್ ಪ್ರತಿನಿಧಿಯನ್ನು ಬದಲಾಯಿಸಿ ಮತ್ತೊಬ್ಬರನ್ನು ನೇಮಕ ಮಾಡಿ ಕಳುಹಿಸಿಕೊಡುವ ವಿಷಯ.
Yes.
There was nothing hidden or anything. Meeting notice is served on petitioners also. Though they say they are not served with the meeting notice, I can point out with reference to their signature, but these are matters of disputed questions of fact. Therefore, with this very particular meeting is called. In the meeting, the reason given is it was by mistake that Mohan Reddy was made. We are making Raja Reddy as the delegate. Mohan Reddy has no objection. He is the president of the meeting. He says, yes, it is so, it should be done. The substantial reason, etc., are all with reference to the existing delegate. It's only he.
The president is a default delegate.
Yes. With reference to the existing delegate, this he has the right to question, saying that is not the situation. I still remain the delegate. There is no 2/3. It is not substantial reason, even if there is 2/3, etc. Is something which is given to the a right, a safeguard. That would be the situation. Now, fact situation, your lordship may kindly take. Assuming something is wrong or etc., society is the member whose name finds a place in the electoral roll. A person is required to represent and vote on its behalf.
Yes.
2/3 members of the society have passed a resolution saying Raja Reddy should be our delegate in the place of so and so to vote, and that person's name is reflected, accepted, and he has voted. In what way would it make this thing, except saying no, none of these things should not take place at all? I would respectfully submit there is provision for making the change. Making the change is permissible up to the last 15th day. Of course, they may say within time you have not sent. There can be a case where newly elected committee passes a resolution after all these time limits. Returning officer may not permit. Some of them have approached the court and they are permitted to vote because that is the in a substance. A society which is a member cannot be deprived of the vote in this technical of voting. Therefore, my submission is all other things with reference to powers of 39A, etc. I would say 39A power of the officer to see whether resolution is passed. If someone has objected to that resolution, it's a provisional list. If someone objects to that resolution, probably there would have been an inquiry. In this case, 12/5.
And elections were held on
28/5.
28/5.
28/5.
And
16 ದಿವಸ ಮೊದಲು ಮಾಡಿದ್ದಾರೆ.
And 2 days before that petition.
Yeah. Now that the legal tangle is over, I would say this this first petitioner said he may be substituted. He had participated in the meeting. It's our this thing. He participated in the meeting. He wanted his name to be proposed. Yet all of them who were present, except probably 2 and 3, petitioners 2 and 3, he did not get the support. That's altogether a different aspect now that things were being discussed. That's how these
3
things.
and 4 alva, very true.
4 is object.
4 absent, 4 ಇರ್ಲಿಲ್ಲ. 4 ಇರ್ಲಿಲ್ಲ. 4 ಇದ್ದಿದ್ರು ಅವ್ರನ್ನ ಜಾಯಿನ್ ಆಗ್ತಿದ್ರು ಅಂತ ಹೇಳೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಬಟ್ ಎನಿವೆ it's okay. Therefore, ultimately what would be considered is society is the member which casts the vote, and society is to be represented by a director. The society is to be represented by a director. Then much was made. I don't know why that argument was advanced, that in 21(3) a different phraseology is used. It is not so.
It's only an addition.
It is, even as an addition also, I would say it's not so. Kindly see.
It only amplifies and makes it clear. So 21(3), delegate. Yes.
A member once nominated on its behalf in the affairs of the other cooperative society.
That argument was as regards E1A, not as regard 21(3). Change by way of amendment is to section 2 E1A, delegate definition.
Delegate definition, it remains a delegate. Whoever is elected under 21(2)A remains a delegate.
Only addition is with power to participate and vote in general.
It says who has been nominated under clause A of subsection 2.
Yes.
Every delegate is nominated only under clause A of subsection 2.
But now the reason which has been recorded in the minutes is different
Yes,
from the
reason
in
that
your-
has been recorded in the minutes, I would say this, my lord. Both of them are present, 6 and 7. They say it should have been Raja Reddy. It is recorded as Mohan Reddy.
But he says now in the affidavit.
Mohan Reddy says, yes, it is so. You please change it to.
First he says that the delegation of him by unanimous vote is correct. But then he says
Yeah,
he did
there
not
is-
want to go, therefore
No,
changes happened.
First, there is a delegation, a resolution has been submitted. They could not have gone back saying, because it was submitted to the authority with his name. Therefore, notice was issued, badala isalikke.
In the affidavit which has been filed at para 7
Please, Miller.
of respond number 6, he says a different thing than what is contained in the resolution.
No, not in that sense, my lord. The averments made in para 2 of the writ petition that there are 11 directors, is 7 was elected as a delegate. Reason given by them is it was a mistake in nominating Mohan Reddy.
Mistake by the CEO.
CEO in recording the name.
Why
It
are
could
you
be,
blaming-
it could be any reason. It could have been a plainly a reason saying I have resigned from being a
Could
delegate.
have been,
That it amounts to same, nothing
Not.
more than that.
but it is not.
It amounts to same thing and nothing more than that. That's why I said it is not these two persons who will be the voter. Voter is society. Who should represent that society is only 21(2).
Yes.
Society is in the eligible list. There has to be someone.
Yes.
And for a moment, let us assume that this resolution is not there. Respondent number 6 himself was the delegate. It would not have made any difference because the changed delegate did not contest the election.
Respondent number 7 did not.
He did not contest the election. And there is no disability for respondent number 6 to be a delegate of this society. For respondent number 6 to continue as a delegate of this society also, there was no disability, except that another person should be given a chance.
Why did you do all this?
This is because their own way of understanding the things. If they had asked someone who knew about these things, they would have said, please resign.
Nomination to two.
Allah.
The nomination to two societies by the same society na different interpret ಆಗಿದೆಯಾ?
ಅದೆಲ್ಲ ಮಾಡೋದು ಯಾರನ್ನಾದ್ರೂ ಕೇಳಿದ್ರೆ they would have said simply you resign.
ಅವ್ರಿಗೆ ಎಲ್ಲ ಚೆನ್ನಾಗಿ ನೀವೇನು ಹೇಳ್ತೀರ?
ಅಲ್ಲ they could have the
affecting anything.
Affecting the petitioners or anybody else.
No prejudice is caused.
No prejudice in any way it is caused. On the other hand, if anything else is done, an eligible society is deprived of its vote.
Yes.
Therefore, my respectful submission is the power of election authority, etc., to consider and decide would have arisen if there were to be a objection by someone. Objections.
Yes.
The society has filed its statement of objection. Of course, my learned friend appears. I would only point out statement of objection filed on 20th June 2025.
Yes.
In that, my lord, your lordship may kindly go to that meeting was held, etc. All these things is stated by the society.
Yes.
Therefore, their presence, signature, etc., if that causes the reason for dispute, cause, that is something which they will have to be relegated to a proper forum where evidence would be necessary.
More to be
nothing. Unnecessary. I do not want to burden your lordships unnecessarily.
Reply in
Government, I think, wants to place on record the elections.
Regarding my lord, we have kept in the separate ballot box, my lord, as per the interim order. We have not said anything, my lord.
elections results have not been announced. Third.
Way of reply, only submission is the theory that no prejudice have been caused. That appears to be not correct because suppose one delegation is there today. For any reason, the warranting circumstances are there to change it. Then once changes is warranting, then may not everyone among 13 are entitled to say, I wanted to be. How the things have been manipulated is, they are predetermined. X is there in place of X, we wanted to place the Y. That ultimately forthcoming in the resolution. Therefore, they may not say that intersect because two persons have been benefited, but others 11 are concerned. Their freedom to have a say in the matter, either by participation, otherwise, it is not provided. It is a prejudice to us.
By the famous thing, democracy is a tyranny of numbers.
Correct.
Third, Shri M.R. Rajgopal, learned senior counsel for the petitioner. Shri Jaikumar S. Patil, learned counsel for respond number 6. Shri Pauling Navadi, learned counsel for respond number 5, 7 and 8
Amendment application may kindly be allowed.
on the main 7 and 8
Amendment application may kindly be allowed.
on the main
I will place the amended.
must IA 1, 2, 3 of 2025 reserved.
Amendment application.
We'll decide what to do,
Very good.
all of them.
Anyhow, grateful of this to other things. Anyhow, a legal issue. we have-
10 ನಿಮಿಷದಲ್ಲಿ ಆಗುತ್ತೆ ಅಂದ್ರೆ ನೀವು ಇದಕ್ಕೂ ಇಷ್ಟೊತ್ತು ಮಾಡಿದ್ರಿ. Yes.
ಆಗ ಅಂತ.
Yes.
They have taken too serious.
Lord,
Voting, my lord.
Voting.
voting and contesting the
No
election. my lord.
contest. Contest ಇಲ್ಲ.
My lord, kindly see
R1.
the
R1.
We are
voter
not
list
doing-
prepared by the, your lordship, kindly see the
AG
page number
access
20.
notice for
R1,
respond number 1, 3,
3, 4,
4.
2 is Kiran Kumar, my lord.
Kiran Kumar for
Five.
2, issue emergent notice to respond number 5. ಯಾವ್ದು election?
27.
Lordship, kindly see the page 24
Returnable
of the
by
petition. my lord.
31st July. Counsel for the petitioner is also permitted to take out hand summons on respond number 5. Yes, ಹೇಳಿ.
Your lordship, kindly turn page 24 of the petition, my lord. Annexure, the last page, my lord.
Yes.
Even in the statement made by the fourth respondent in the, your lordship, kindly turn item number 9, my lord.
Yes.
ಕಳೆದ 5 ವರ್ಷಗಳಲ್ಲಿ ವಾರ್ಷಿಕ ಸಾಮಾನ್ಯ ಸಭೆಗಳಲ್ಲಿ 3 ವಾರ್ಷಿಕ ಸಾಮಾನ್ಯ ಸಭೆಗಳನ್ನು ಹಾಜರಾದ ಬಗ್ಗೆ ನಿರ್ವಹಿಸಿರುವುದಿಲ್ಲ.
Hmm.
So even my petitioner is
Petitioner is,
2013, he was a member of the society. my lord.
what is the disqualification for petitioner?
But there is no separate order for the
A4 and A5.
A4
disqualification.
A5?
A4, both ಇದೆ ಅಂತ ಹೇಳಿ.
A5 ಇದೆಯಾ?
Please.
A5 ಇದ್ರೆ ಇಲ್ಲ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ
Vote.
ಲಾರ್ಡ್ಶಿಪ್ ಕನೆಕ್ಷನ್ ಏನಲ್ಲಿ 2013 ಅಲ್ಲೇ ಮೆಂಬರ್ ಆಗಿದೆ.
A4 we are giving exemption, A5 ಇಲ್ಲ. There's a A5 issue, even later after voting also there could be a problem.
And moreover, my lord, challenge the virus of the act also.
Virus challenge ಮಾಡಿದೀರಾ?
ಅದು failed ಆಗಿದೆ sir.
Since the virus of section 22, A4 and A5 of the Karnataka Corporate Societies Act has been challenged, notice is issued to learned.
I'm for the petitioner, my lords. Next week,
Next week ಆಗಲ್ಲ. 31st or 1st.
please, 31st,
Relist on 31st
31st.
July.
Interim order in
Interim order
48.1.
where granted is extended till next date.
In the connected matter, in my
Where
matter,
granted?
please.
Please.
My lord, I am appealing for respondable to.
Rangappa Bovi, party in person.
I am appealing for respondable to, my lord.
Yes, notice ಹೋಗಿದ್ಯಾ?
He himself has moved, my lord.
He himself has moved.
Yes, my lord, he himself has moved, my lord.
14% move ಮಾಡಿದ.
He's party in person, my lord.
Party ಇಲ್ಲ.
ಎಲ್ಲಿ ಮೆಮೊ ಎಲ್ಲಿ ಅವ್ರದ್ದು? ಇಲ್ಲಿ ಏನ್ ಮೆಮೊ, photo ಮೆಮೊ. None appears for the petitioner. Relist on 1st August.
Obliged, my lord.
One,
Relist on 31st August,
52,
Appearing for the petitioner.
1st August.
A very short question. My pleading application has been.
ಯಾರು ಇಲ್ಲ ಇಲ್ಲಿ.
ಅವರು ಸಿದ್ಧಾರ್ಥ್ ಮುಚ್ಚಂಡಿ ಅವರು.
ಇಲ್ವಲ್ಲ.
I'm appealing to, I may be permitted to appeal to your lords.
Are you ready?
Yes, your lords. I have filed my statement of objections here. Everything is done. I'm ready.
What is the short matter? 5 o'clock.
Petitioner filed an impleading application before the second respondent, which has been rejected by the
Who do you want to implead?
respondent number 7 to 17.
Who are they?
What happened, my lord?
Who are they?
ಎಲ್ಲರೂ ನಮ್ಮ ಮೇಲೆ ಆಗ್ತಾ ಇದ್ದಾರೆ. That is the thing.
Yes, any objections for that IA?
They appeared before second respondent.
Impleading application.
Lordship, my statement of objections is looking for.
Notice to those impleading applicants ಆಗಿತ್ತಾ?
ಆಗಿದೆ.
They had appeared.
ಸರ್ವ್ ಆಗಿದೆ ಅವ್ರಿಗೆಲ್ಲರಿಗೂ. ಬಟ್
ಇಲ್ಲಲ್ಲ.
ಅಲ್ಲಿ ಸರ್ವ್ ಆಗಿ they appeared and passed the exhibit.
They contested the
They
application.
contested.
Then we'll have to hear it.
My lord, respond number 2, 3, 4
ಅಲ್ಲ,
state will take notice.
page number
And
144
AGA
may kindly
accepts
see.
notice for respond number 2,
2, 3, 4,
and
ma'am.
4. Registry direct print his name as such. Relist on 31st.
Please. Interim order may kindly be extended.
Interim order.
53,
1st August.
55,
1st August.
Interim order may kindly be extended.
Interim order.
56,
56 ಏನಪ್ಪ ಇದು ಎಲೆಕ್ಷನ್
ಇಲ್ಲ
ಎಲೆಕ್ಷನ್ ಅಂತಿದೆ. ವೋಟಿಂಗ್ ಬೇರೆನಾ ಇದು?
ಫೈಲ್ ನಾನು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೆ.
56
ಕಾಪೀಸ್ ನಾಟ್ ಬೀನ್
ಕೊಡಿ ಏನು?
My lord, kindly have it on next week. my lord.
Is it voting matter or
ಅದು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. CCMS ಸಹ ಓಪನ್ ಆಗ್ತಾರ, ಅದು ಸಿಕ್ಕಿಲ್ಲ ಸರ್.
no, it's not a voting matter. No, it's not a voting matter. That counsel for the petitioner undertakes to furnish a copy, 2 sets of the petition along with annexure and learned AGA by end of day 23rd July. Learned AGA is granted 3 weeks time thereafter to file a statement of objection, objections if any, by 14th August, relist on 21st August.
My lord,
Interim order earlier granted is extended till next day.
Please.
57,
57 is my lord. I have filed my objection, my lord. It's a government
Readings.
non.
FSL report.
Interim order is there, my lord. 58.
This is that minutes of meeting.
My lord, signed by the CEO, my lord, of the last of Ramesh is appearing, my lord, regarding the board.
The minutes of meeting, ಅದು book ಎಲ್ಲ ತಂದಿದ್ರಲ್ಲ.
Please.
Relist on 1st August.
Serial number 50.
Oblige.
Interim order may be extended.
Interim order ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆಯೋ extend ಆಗುತ್ತೆ.
55 interim order.
ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆಯೋ extend ಆಗುತ್ತೆ.
59.
67th.
membership, my lord.
16.
The last 16.
Lords, I appear for respondent number 6, my lords. We will advise the society to consider their membership, my lords, in accordance with law, with the bylaw, my lords. My statement may be recorded.
Petitioner 60. Petitioner is before this court seeking for the following reliefs.
60.
Now they are residing there.
Please, my lords.
Land counsel for respond number 6. Submit that the fresh application submitted by the petitioner for grant of membership would be reconsidered in accordance with law. His submission answers the grievance of the petitioner. Placing the said submission on record, petition stands disposed. 61.
Grateful, man.
The petitioners,
Attachment notice.
they obtained the interim order.
31st, 61, 31st.
Oblige.
62, Lakshmish.
A small matter, notes. My membership has been deprived by the first respondent bank. Consistently, I made 2 applications. I have furnished all the documents. But in spite of that, my lord, they are insisting for some other document which becomes
Issue
irrelevant.
bailable warrant to respond number 1 and respond number 2, returnable by 31st July, both of which quantified for a sum of rupees 10,000. Since it was the duty of the concerned officers to be represented.
ಬ್ಯಾಂಕ್ ಮೇಲೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಕಂಪ್ಲೈನ್ಸ್ಗೆ ಅಂತೇಳಿ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ರೆ ಅವ್ರ ಅಫಿಡವಿಟ್ ನ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹಾಕಿದ್ರು ಮಲ. ದಟ್ಸ್ ವೈ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮಾಡಿ ಅಂತ ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿತ್ತು ಮಲ.
Recovery matter.
ರಿಕವರಿ ಮಲ.
ನೀವು the second respondent might have filed certain documents today.
ಆಲ್ರೆಡಿ
We have to go through the document.
ದುಡ್ಡು ಕೊಟ್ಟಿದಿರೋ ಇಲ್ವೋ ಹೇಳಿ.
Merits ಮೇಲೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ.
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಏನಿದೆ ಒಂದ್ಸತಿ ಯು ಅಕ್ಸೆಪ್ಟ್ ಇಟ್. ಡಿಸ್ಮಿಸ್ ಆಗಿ ದುಡ್ಡು ಕೊಟ್ಟು ಏನಾದ್ರು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿ. ಯು ಡೋಂಟ್ ಸೆಟಲ್, ಇಟ್ ವೋಂಟ್ ಹೆಲ್ಪ್ ಯು.
We'll
ಇಂಟ್ರೆಸ್ಟ್
put
ಹೋಗ್ತಾ
it
ಇರುತ್ತೆ.
the matter to the petitioner, what you would say. We'll
Mediation ರೆಫರ್ ಮಾಡೋಣ. That is one more thing we have thought of.
mediation.
Since there's a mediation drive now, all these recovery matters
Please.
can be referred to mediation to see if it can be settled.
ಸಿನ್ಸ್ 4 years ಮಲ 21 ಅಲ್ಲಿ ಅವಾರ್ಡ್
ಹೌದು,
ಆಗಿರೋದು.
ಒಂದು mediation try ಮಾಡಿ ಏನಾದ್ರು ಬಂದ್ರೆ
ಲಾಸ್ಟ್ ಟೈಮ್ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮಾಡ್ತಾನೆ ಅಂತ ಹೇಳಿ
ಒಬ್ರುನು ಇವ್ರ ನಿಮ್ ಆಫೀಸರ್ ಹತ್ರನೂ ಬರ್ತಾ ಇಲ್ಲ.
ಬಂದಿದ್ರು ಮಲ್ಲ ಪ್ಲೀಸ್.
ಬಂದಿದ್ರ ಇದ್ರಲ್ಲಿ ಓಕೆ. ಮೀಡಿಯೇಷನ್ ರೆಫರ್ ಮಾಡೋಣ.
Maybe refer to mediation. There we will try.
There is a possibility of a settlement being arrived at, since the issue is as regards payment of monies by the petitioner to respond number 2. Hence the matter is referred to mediation by the Karnataka Mediation Center. The Director Mediation Center is directed to appoint a suitable mediator to try and mediate the dispute between the parties. Both the parties shall be present before the Director, Karnataka Mediation Center, without requirement of any further notice at 2:30 PM on 24th July, 2025.
Please.
Relist after receipt of the mediation report.
Other than 24, no, my lord.
25th.
63,
Relist after mediation, receipt of the mediation report.
63, my lord, it's only show cause notice.
Prior of the third petitioner, para C, there is a direction, my lord. Several complaints are pending before the fourth respondent, my lord. Para C, page 29, my lord.
Lord, the first.
Fourth respondent is sitting on several complaints, my lord, which he has to adjudicate, my lord. That is pending. One thing. Lord, now there is an allegation made against the JRCS, my lord. The only impediment, my lord, if my lord directs me, my lord, I may be permitted to file my recourse at Bangalore, my lord, since he is a JRCS is having a 8 district, he is a officer where I may not get justice in the event I approach the Mysore. Not, it is a fact, my lord. He is the author of the entire thing, my lord. From past 17 years, he is sitting in the place, my lord.
That submission, that would demoralize everybody if we accept that submission.
Choose the forum. You cannot choose the
Wherever the jurisdiction is, you will have to go there.
Lord, what happens, my lord? Not the result is clear, my lord. I may not succeed there, my lord.
That JR Bari in N district, in 31 district ilva.
revision to appeal registrar ಗೆ
Lord,
appeal.
31 district allೂ JR our friends ಇರೋದು. You cannot say that. Then we'll have to send you outside the state.
Lord, at least I may be permitted to file at Bangalore, my lord.
No. File it
My humble
wherever the
request, my lord,
jurisdiction
since there is allegation made
Documents are
against
there,
him.
everything is there, file it there. Again, you want to mandamus on kotu, you want liberty to file.
Lord, please,
Division.
my lord, on last day expressed, my lord, since I was not amended, I sought time to amend, my lord. Now my amendment had been carried over, my lord. The number of parties have been arrived, my lord. I filed an amended cause title to bring all the elected representatives as a party to the petition, which I have done, my lord. I
Yes.
filed it in the office.
Now what do you want? You want to address argument or you want
Lord,
to
I'm not,
reserve
since I'm
liberty?
not going against my lords. Lord, my only thing is that, my lord, I had an apprehension since we have allegations against the JRCS. Lord, I may not get justice if I place my proceedings before the same authority, my lord.
To file a revision.
No.
In the jurisdictional forum, you can file the revision. You want to withdraw and file it there.
Lord, I'll file, my lord, but annexure, my lord, mandamus, my lord, may direct several complaints are pending,
Yes,
which
we'll
can be
observe
allowed.
that. We'll observe that.
That is joint register has to consider.
Petitioner is before this court seeking for the following leaves. After arguing for some time, the counsel for the petitioner seeks permission to withdraw the above petition with liberty to file a revision under section
70, my lord.
70, my lord.
Dispute.
Not
dispute
my lord.
revision.
Pertaining to, my lord.
Dispute under section
Lord, there
70.
are two folds, my lord. One is regarding service of petitioner number 1 and 2. Petitioner number 3 challenge the very election, my
Club
lord.
ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Separate.
Under section 70 of the Karnataka Corporate Societies Act 1959, as regards the grievances of the petitioner, if necessary, by filing multiple disputes. Reserving such liberty, the above petition
Or a
stands
time frame may
disposed.
be fixed, my lord, since it's an election.
Okay, you first file, they will do it. You time frame ಎಲ್ಲ fix ಮಾಡ್ಬಿಟ್ರೆ ಮತ್ತೆ it will definitely go against you.
Lord, my humble request was, my lord, it
Submission
could
of
have been
the
filed
counsel
at
for the
Bangalore, my lord.
petitioner is also
Yes,
that
allegations
there
are
are
made
several
against the
complaints
JRCS.
which are pending before the fourth respondent for inquiry, which have not been disposed. The first respondent is directed to look into the said aspect. Is directed to look into the said aspect. ಅವ್ರು ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತಾನೆ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್. they directly look into the said aspect, and if there are, to call for a report of pending matters, and if there are pending matters, to issue necessary instructions to the fourth respondent to dispose of the same in a time-bound manner.
Authorized.
68 and 46.
My lord, kindly have it on 24th, my lord.
We issue the, my lord, directions to submit that, my lord, 11/11/6.
Paper committee has directed you to appear.
Appear, my lord.
70, Kodi. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that on the basis of an instruction issued by the committee on papers laid on the table, respondent number 1 and 2 have issued the correspondence at annexure A and B calling upon the petitioners to furnish certain documents and to appear before the committee on papers laid on the table. This aspect has been dealt with by this court in WP number so and so, when this court has categorically come to a conclusion that in terms of Rule 291
290 and
of
291.
291
and 291 subclause
291 of so and so rules, there's no power with the said committee to call for any documents or to summon any witness. In that view of the matter, I pass the following order. Writ petitions allowed. Writ petitions are allowed. So and so certiorari A and B are set aside.
71.
That's it. This case, I am for the respondent. It is short date lad, because they are disqualified under section, my contention is they are disqualified under section 18 A and B. That's
31st August, July. Voting.
Voting.
Declare results. Aita.
Declare ಆಗಿರೋ, it is pending.
ಅದೇ declare ಮಾಡ್ತೀವಿ.
Yes.
Declare result 72. 73.
My lords, appearing for respondent here, my lords, your lordship's order has been flouted and they have taken undue advantage without paying any money, my lords. They have taken the
The interim
petitioner
order
is-
has not been complied with. Is placed on record, relist on 24th July.
I heard that my petitioner is now dead. 2 days back, he is also no more. But there are 2 other petitions by his brother-in-law. That is also pending.
Kodi number kodi. Connect with so and so.
Find my statement of objections along with that, my lords.
Connect with
Yes,
number kodi, connect
Please,
ಮಾಡೋಣ.
please,
So next date it will come.
please.
One submission, my lord, 60.
74.
I am for respondent number 6, my lord. Kindly 2 weeks time may be granted to file objections. My lord.
One seeks for 2 weeks' time to file a statement of objections by 7th, relist on 14th.
Much obliged.
Passed over matter.
Oh, one submission, my lord, 65, which has been referred to mediation. There is an interim order that will be kindly be.
65 interim order extended.
Serial number 10.
My lord.
Like tomorrow it can be taken up to 30, my lord.
Relist tomorrow 10.
Much.
My lord, this was memo as requested, my lord.
Land Council for Respondent has filed a memo which is taken on record, copy thereof. He is acknowledged to have been received by the council for the petition.
Much obliged.
Banta ilwa?
Okay.
Sign ಹಾಕಿದ್ದಾರೆ.
ಅಷ್ಟೇನಾ?